Before Ajit Pai and the FCC voted to repeal Title II net neutrality protections last year, there was already a legal battle that was being waged over the 2015 net neutrality rules, because the same telecom industry that lobbied for Ajit Pai to kill these rules was already trying to get them killed in the courts by suing over the 2015 Title II net neutrality protections. And unfortunately for lobbyists of companies like AT&T and Verizon, a court did not rule in their favor. And this is why they still were lobbying for Ajit Pai to repeal those Title II rules, because they couldn't win that way. Now, this legal battle has been ongoing, and it hasn't gone in their favor. And today, we got another update to the old 2015 legal battle over net neutrality, and also a pretty significant legal victory. Surprisingly so, because the Supreme Court actually rejected their appeal once they lost. That is, the appeal of telecom lobbyists, and as a result, legally, Title II stands. For now, because remember, we're juggling multiple legal cases when it comes to net neutrality, because this is pertaining to the 2015 securing of net neutrality under Title II, and now there's two more cases that were catalyzed after the FCC's 2017 repeal of net neutrality. We have 22 attorneys general from states trying to sue the FCC to get them to undo their repeal of net neutrality, and also we have the Justice Department suing the state of California for codifying their own net neutrality rules into law. But at least when it comes to this issue, we did get a legal victory, which is good for a number of reasons. So for more details on this specific case, we're going to go to John Brodkin of Ars Technica, who reports the U.S. Supreme Court has declined to hear the broadband industry's challenge of Obama-era net neutrality rules. The Federal Communications Commission's 2015 order to impose net neutrality rules and strictly regulate broadband was already reversed by Trump's pick for FCC chairman, Ajit Pai, but AT&T and broadband industry lobby groups were still trying to overturn court decisions that upheld the FCC order. A win for the broadband industry could have prevented future administrations from imposing a similarly strict set of rules. The Trump administration supported the industry's case, asking the U.S. Supreme Court to vacate the Obama-era ruling, but the Supreme Court today said it has denied petitions filed by AT&T and broadband lobby groups NCTA, CTIA, U.S. Telecom, and the American Cable Association. 4 of 9 justices must agree to hear a case, but only 3 voted to grant the petitions. According to the Supreme Court announcement today, Justices Clarence Thomas, Samuel Alito, and Neil Gorsuch, quote, would grant the petitions, vacate the judgment of the United States Court of Appeals for the District of Columbia Circuit, which upheld the FCC's net neutrality order, and remand to that court with instructions to dismiss the cases as moot. Chief Justice John Roberts and Justice Brett Kavanaugh recused themselves from the case. Roberts owned stock in AT&T-owned Time Warner, while Kavanaugh took part in the case when he was a judge on the D.C. Circuit Appeals Court. Bloomberg Supreme Court reporter Greg Stoher noted. Kavanaugh dissented from the ruling upholding net neutrality rules in 2017, arguing that the rules violate the First Amendment rights of internet service providers by preventing them from exercising editorial control over internet content. Today's Supreme Court decision is good news for supporters of net neutrality because it means that the D.C. Circuit Court's previous decision upholding both the FCC's classification of broadband as a telecommunications service and its rules prohibiting broadband providers from blocking or degrading internet content remains in place. Senior counsel John Bergmeyer of consumer advocacy group Public Knowledge said. So this is phenomenal news for supporters of net neutrality, and my hope is that this is going to strengthen our legal argument when it comes to net neutrality and the war over net neutrality that's currently being waged legally. Now, this does give us a little bit more insight into how this will go for us, because for one, Brett Kavanaugh recused himself here because he already ruled on this at the lower level. So what does that mean? In the event there's enough justices to actually hear out net neutrality at the Supreme Court level, well, Kavanaugh may still recuse himself. And seeing that Chief Justice John Roberts recused himself since it's a conflict of interest, since he owns stock in Time Warner. Well, he may also have to recuse himself. So if both of those justices refuse to hear the current net neutrality cases, or if they do hear it and they recuse themselves, what does that mean for us? Well, if all of the justices hold strong and they vote the way that we expect them to, that is, that the liberal justices vote to uphold net neutrality and the conservative justices vote to strike down net neutrality, that means we could very well win this by a 4-3 margin. So this is good news, and I don't want to, make you feel as if it's a sure bet, because this doesn't necessarily mean that we're going to win. It doesn't guarantee a win by no means, but it does give us a really good sign that we actually do stand a chance, because net neutrality legally, it is something that's been upheld. And if it's been upheld, then clearly Ajit Pai repealing this order, well, perhaps they'll look to that precedent and see clearly this was illegitimate, and they'll strike it down. So look, I have no idea how this is going to go, but this does give me a little bit more of an optimistic look heading into the courts when it comes to the legal battle regarding net neutrality, because as it stood, in the event Kavanaugh and John Roberts did not recuse themselves, well, I mean, undoubtedly it would be the case that net neutrality wouldn't have survived if it made its way to the Supreme Court. Certainly, if all conservative justices heard this case and they accepted this 2015 challenge to the FCC's Title II protections, they would have voted against it. But since they were surprisingly principled and decided to recuse themselves for good reason, this helps us. So again, I don't want to get your hopes up, but understand that we need every single victory to make sure that supporters of net neutrality don't feel demoralized and feel as if this is a lost cause, because this is in no way a lost cause, and it's going to be a long and lengthy legal battle, but this kind of gives us a look at how judges might rule, and it kind of gives me the impression that this probably won't make it to the Supreme Court. If John Roberts can't hear a net neutrality case because of a conflict of interest, then odds are he's going to recuse himself if this makes it to the Supreme Court again. So, if he remains principled, that is. So, look, this is good news all around. Take a win where you can get it. But this isn't the end of the net neutrality legal battle. Far from it. But, I mean, still do what you can to fight for public broadband at the local level. Because if there's going to be anything that ends this debate once and for all, it's going to be public broadband in your city. So do what you can to make sure that that's on the agenda of your city council. But in the meantime, let's celebrate this, because this is definitely good news.
Support this podcast by becoming a patron at patreon.com/Humanist Report.